may be seated. We have 3 cases on the docket to be heard this morning. We'll call them as shown on the docket sheet. After the first case, we will break for coffee in the Commons, and we ask all of you to join us for about 10-15 minutes. Our first case is K.J.S. versus Department of Children and Family Services. Appellant, ready to proceed?
May it please the Court, I'm Michael Upperman and I represent the appellant Kenneth Scurry. I'd like to reserve 5 minutes of my time for rebuttal. The issue before the Court this morning is whether or not it was proper for the Department to reject the administrative law judge's finding of fact that Mr. Scurry was rehabilitated. Mr. Scurry sought to be a resident in a home where a daycare center would be operated. Chapter 435 states that a person is ineligible to be in a position of trust if that person has certain convictions in his or her past.
He doesn't live in the home now?
I think he does, and I think the home, therefore, is not eligible to be a daycare center, is my understanding.
Is there a pending application for licensure?
I think, I don't know if I can answer that question, Your Honor. I think that if his exemption is granted, then he'll be able to live in the home, and then the daycare center will be able to be operated in that home. I think my client's wife, Mrs. Scurry, has obtained an exemption, and she's permitted to run a daycare center in her home. The restriction right now is simply that her husband, Mr. Scurry, is not permitted to be a resident in that home, and because of that, they're not going forward with the daycare center.
So she has a license?
Yes, I believe that's correct, Your Honor. I think the record does reflect that she's been granted an exemption. I think the Department pointed out in their answer brief that it's not clear why she needed to request an exemption, but she's been granted that exemption. Mr. Scurry, when he was 22 back in 1984, was involved in a criminal episode that later resulted in his convictions for second-degree murder and armed robbery. The record is undisputed that he was a getaway driver in that criminal episode. It was supposed to be a robbery. He was not the person that went inside the convenience store. There was no plan whatsoever that anyone would be murdered as a result of that criminal episode. In fact, I think my client found out much later that someone was murdered. The record also establishes that the gun involved in the robbery apparently went off accidentally. The lead detective, Mr. Carr, testified that it was a faulty gun, so this was an accident. It was not a planned murder, and those are the convictions that...
Do the actual facts of that 1984 offense really make any difference?
I think it's one factor that can be considered by the administrative law judge in making the finding of fact as to whether or not my client is rehabilitated. It's one of several factors. I think 435.073 states that the circumstances to be considered as to whether or not someone is rehabilitated include, but not limited to, the circumstances surrounding the criminal incident, the time period that has elapsed since the incident, the nature of the harm caused to the victim, the history of the employee since the incident, or any other evidence or circumstances indicating that the employee will not present a danger if continued employment is allowed. So I think that's one factor that needs to be considered by the administrative law judge in making the findings of fact. Mr. Scurry served about 13 years in prison. He was released in 1997.
Well, your client didn't help the process by misrepresenting the facts surrounding the crime.
Your Honor, I think that in a case like this, it's somewhat understandable in the sense that someone who's charged with second-degree murder and has a principle to second-degree murder may not fully understand that the law is holding them responsible for a murder. I think, again, the record is undisputed that my client was not the trigger man. He did not shoot any gun. But, of course, he's being held responsible under the law because he was a principal to this armed robbery and then also the murder that occurred during the robbery. So I think that's one aspect that can be considered. Another aspect to be considered is that Mr. Carr, the lead detective from the 1984 incident, testified at the administrative hearing and said that Mr. Scurry, at the time of the incident, was very forthcoming, fully acknowledged that he was responsible in this incident, fully explained to the police his involvement. There was no indication from the lead detective in the criminal incident that my client ever tried to minimize his role in the offenses.
Why isn't Hepburn dispositive of this case adverse to your position?
No, I don't think so, Your Honor.
Well, tell me why.
I think the issue in this case is what happens when someone who has been denied an exemption pursuant to Chapter 435 pursues the formal review process under Chapter 120. Mr. Scurry did that in this case. I believe that Mr. Hepburn did that in the Hepburn case. In Hepburn, I would argue that the record did not contain competent substantial evidence to support the administrative law judge's finding that Mr. Hepburn was rehabilitated. The main fact I would focus on is that in Hepburn, the defendant or the applicant was released from prison 1 year prior to the date that he sought the exemption. In our case, Mr. Scurry was released from prison in 1997. More than 8 years later, he filed for the exemption, and the exemption was filed several years after the 1984 offense. So I think,
Counselor, in that Hepburn case, they didn't have a transcript there, and it said that it was not necessary for the department to review the transcript before modifying the hearing officer's recommendation.
I think that's right, and I think the reason was because of the 1 year issue. They said there's no transcript that's needed to ascertain when he was released from prison versus when he's filing for the exemption, and that's simply not sufficient time for us to be able to determine that anyone would ever be rehabilitated. Those simply aren't the facts of our case. In our case...
But it looks like this court just said it found that the department had the discretion to deny it in this situation, notwithstanding the recommended order.
And I don't think the court said that. And I would ask the court to relook at that.
It fools me if they didn't. I mean, the wording seems very much directed in that way.
Well, Your Honor, I guess I would start from the proposition that when someone invokes the Chapter 120 process, at that point, if there's disputed issues of fact, it's up to the administrative law judge to resolve those disputed issues of fact and make findings of fact. I submit that in this case, whether or not Mr. Scurry was rehabilitated is a finding of fact. The administrative law judge heard several witnesses at the administrative hearing, and the overwhelming majority of those witnesses testified, opined that my client was rehabilitated. The administrative law judge, after hearing that live testimony, after hearing those witnesses, assessing their credibility, made a finding of fact that Mr. Scurry is rehabilitated. Florida law is clear that when an administrative law judge makes a finding of fact, the department is required to follow that finding of fact unless there's not competent substantial evidence to support that. In Hepburn, there was not competent substantial evidence to support it. In this case, I submit there's no way for this court to conclude that there's not competent substantial evidence to support the administrative law judge's finding that my client was rehabilitated. And that's the framework we must judge this case under. If otherwise, there would be no reason to invoke the Chapter 120 process in a Chapter 435 proceeding. But I would note that Section 435.073 specifically states that the decision of the licensing department regarding an exemption may be contested through the hearing procedures set forth in Chapter 120. The legislature has mandated that this type of...
Now, on page 10 of the recommended order, the ALJ is not talking about whether or not K.J.S. was rehabilitated. He says that denial of the request, the contention is that denial of the request was proper. The department's contention is denial was proper because of the severity of the offense. We are talking about a murder. And because of the discrepancies between the official record and the version of events recounted by the petitioner.
Your Honor, on page 10 of the recommended order, and that's focusing on paragraph 21, the administrative law judge says that the evidence of petitioner's complete rehabilitation is clear and overwhelming. That's his burden under Chapter 435. He has to prove by clear and convincing evidence that he's been rehabilitated. That's the finding of fact that the administrative law judge made on page 10 in paragraph 21. That finding of fact must be followed by the department in this case, unless there's not competent substantial evidence to support it. And again, so I think the only question for this court is there competent substantial evidence in the record to support the finding of fact that Mr. Scurry is rehabilitated? If the answer to that question is yes, Chapter 120 in all of the cases, and there's dozens of them in Florida law that have said that once the formal review process is invoked, and once an administrative law judge makes a finding of fact, the department can't reweigh the facts, the department can't make different findings of fact, The department has to follow those findings of fact if they're supported by substantial evidence. They are in this case. Otherwise, again, it would mean that the department in this type of situation, in the Chapter 435 proceeding, is immune from the proceedings and the standard of review set forth in Chapter 120. And I guess this court could issue an opinion stating that, but that's contrary to what the legislature has said. The legislature specifically said in 435.073 that the decision of the department regarding an exemption is subject to the review process in 120. That means that the proper procedure is for the administrative law judge to make findings of fact, and if those findings of fact are supported by substantial evidence, the department must follow those. Otherwise, again, there would have been no need for administrative hearing in this case. There would have been no need to present all of the witnesses. The department, in reaching its final order, didn't even review the transcript. There wasn't a transcript prepared at that time. The department didn't even listen to any of the live witnesses. The one thing I'd like to point out, and then I'll sit down and save the rest of my time for rebuttal, is Mike Murphy testified at the administrative hearing. He's the department's district manager. And he stated that Mr. Scurry's presentation at the administrative hearing was, quote, quite impressive. And he went on to state that seeing people in person versus looking at paper makes a difference. And that's page 142. That's exactly what the Chapter 120 process is all about. Seeing people in person, making those credibility determinations based on the presentation of live witnesses. If the administrative law judge makes those findings after seeing people in person, after hearing the testimony and judging their credibility, and if those findings of fact are supported by competent substantial evidence, the department cannot reject those findings. The department could not reject the administrative law judge's finding that my client was rehabilitated. It's supported by competent substantial evidence. Thank you.
Bill Isaacs, appearing for the appellee. Mr. Scurry didn't testify at the 120 hearing. He wasn't remorseful. He's not rehabilitated, and that's why he didn't get an exemption.
Isn't that a question of fact about his remorsefulness and whether he's rehabilitated or not? And the ALJ has said that he is. So aren't you trying to retry the case?
No, I'm simply trying to point out that on page 128 of the transcript, when Mr. Alexander, who was the screening officer for the department, who was at another proceeding prior to the 120 hearing, was having a direct discourse with K.J.S., Mr. Kenneth Scurry, the former running back for the North Fort Myers Red Knights, told Mr. Alexander in response to his questions, I asked him to outline the events that led up to his arrest, and he told the review committee that on that evening he accepted a ride home from an older man. He did not know this person, did not know the man's ultimate plans. He was just simply accepting a ride from this gentleman. He said on the way home that the gentleman was driving his car. It did not belong to K.J.S. He said they stopped at a friend's house, and then the co-defendant, drove away for an unspecified amount of time, returned, picked him up, and drove him home. And he did not know that he had committed any crime at that time. This is when he's appearing in front of a committee trying to earn his exemption, accepting responsibility for his acts, being remorseful, and being forthright. He's not there yet. He'll get there eventually. He can apply again for an exemption. The department is liberal. They were liberal with his spouse, Lula Mae Scurry. They gave her an exemption. The record doesn't say why she needed one, and I'm certainly not going to tell you here, but she got one. Kenneth will get one too.
Now, what exactly was the basis for the department's denial? It's because he was not rehabilitated?
He was not rehabilitated. He was not forthright. He was not truthful with Mr. Alexander. He did not testify at the 120 hearing. He did testify to Mr. Alexander's committee.
He was untruthful and not. Where does it say that in the final order that he was untruthful?
It doesn't.
Would you agree with the contention that whether or not somebody is rehabilitated is a question of fact?
Of course it is.
What is the basis in the set out in the final order for rejecting that finding of fact?
It was apparent to Mr. Murphy, because he had access to Mr. Alexander's information, since he had access to the committee results, since he had access to Mr. Alexander's testimony at the 120 hearing, that there was obviously a substantial fact reason to believe that he wasn't rehabilitated.
All right, is your answer there is nothing? in the final order to explain the rejection of the ALJ's finding that he had been rehabilitated?
That's absolutely obvious. You're correct.
Can an agency just disregard the ALJ's findings of fact without explanation?
They should not. However, this is a permissive exemption, and that's 435.071. They may grant an exemption. Mr. Murphy's serious about his business here, and as he told the folks there, his job is child safety, and he doesn't take risks.
Well, let me ask you about that. Is there any indication in either order or in the record that he would present a danger if he were allowed to live in this house?
That's impossible for me to know, but I can surmise from the testimony of his witnesses that he's not forthcoming with them. He called a bishop who said in his testimony, he asked this fellow, K.J.S., Kenneth Scurry, about whether or not he was guilty of the charge he went to court for. No, only by association. That was his testimony. That's what he tells everybody else. He has minimized. He needs to grow some. He may get there. The smartest thing Kenneth J. Scurry has done is marry Lula May, who has actually drug him up by the bootstraps. She had a child with him before he went to prison. She married him while he was in prison and has worked assiduously on his character ever since. I'm confident she'll be successful. She just hasn't been successful yet.
When did he commit the crime that involved here?
1983 or 4.
1983 or 84. Had any problems since then with the law?
Not to my knowledge, not by the record.
Well, you keep saying that he's going to make it. Well, he's going to have to. That's been a long time. That's been what, 20-something years?
I think what's convincing is his statements to Mr. Alexander when he's trying to gain the exemption. When he did put himself on public parade and testify to Mr. Alexander and expose himself to being questioned, he wasn't truthful. He wasn't truthful at all.
Was Mr. Alexander's information put before the administrative law judge?
Certainly, it's part of the record. He had it available to him. As far as I can tell, he may have
So the
overlooked.
administrative law judge was able to evaluate what Mr. Alexander had to say about the interview.
Certainly.
And you can reject that evaluation and just rule solely on the basis of what the department thinks Mr. Alexander thought or said.
Well, what he set forth were the certified convictions. He acknowledged that those certified convictions disqualified the man under the statute. And he knew what Mr. K.J.S. had told him and the review committee, specifically when asked the question, what was your involvement? And he denied his involvement completely, totally. And he was in front of Mr. Alexander for the sole purpose of getting an exemption to show he'd been rehabilitated. And to show that, he simply lied.
And the head of the department then can simply take that testimony of Mr. Alexander, accept it as true, and disregard the evaluation and characterization of that testimony by the administrative law judge.
They can't disregard it, but neither can they ignore it. When Mr. Murphy looked at this and reviewing the recommended order and reviewing the record that was available to the administrative law judge, it was obvious to him, and probably with the advice of counsel, my boss, said, this guy wasn't truthful to Alexander. You need to look at that, look at the ALJ's order, and see if you can reconcile what should have been there with what you're asked to do.
Now, who is Mr. Murphy exactly?
Mr. Murphy is was at the time the district administrator of District 8, the department's district in the Fort Myers 5-county area.
Did he have some involvement with the case before it went to the ALJ?
He was probably aware of the screening results from Mr. Alexander. He was probably generally aware through his subordinates of the request for exemption because an exemption had been granted to Mrs. Scurry. And it was probably a bit of a high-profile thing at the time because it involved a murder.
All right, now who would have made the decision to deny the exemption that then resulted in the hearing request?
The review committee that Mr. Alexander was on, who was the screening agent for the department at the time.
Mr. Murphy was not on that committee?
No.
But then it came back to him after the ALJ entered a recommended order? There
was a 120 hearing at which Mr. Murphy was probably present, and the findings of the ALJ and the information, the testimony was brought to Mr. Murphy's attention by his legal counsel, Eugenia Rehak, for his final action. His final action was to deny the exemption, and that brought us here.
So he was getting information from, you say, from his subordinates.
Sure.
And that he may have relied on that information instead of on the findings of fact that came out of the administrative hearing.
I could speculate, but given my knowledge of what's in this record, it looks to me like he looked at Mr. Alexander's testimony and said, I just can't understand how Mr. Alexander can say this in front of the ALJ, and then the ALJ writes this order, because it doesn't look to me like Mr. Scurry's accepting responsibility at all.
In other words, he said, I don't see how we lost at the hearing.
I wasn't there, I don't know. I certainly can't criticize counsel at that hearing because she's my direct supervisor. And y'all unfortunately televise these things. I've said everything I need to say. I just want y'all to remember that Mr. Scurry can reapply. It should be a permissive waiver. It's what the statute says specifically, may grant the exemption. Appreciate your consideration.
May it please the court. Just briefly, it seems that counsel has conceded that this was a factual finding, yet counsel for the department seemingly just wants to ignore the recommended order from the administrative law judge. And that's not the procedure we have in this state. It's not the procedure set forth in Chapter 120. It's not the procedure set forth in the case law. The case law is clear that when an administrative law judge makes a finding of fact, it can only be rejected if there's not competent substantial evidence to support that finding of fact. There is competent substantial evidence to support that finding of fact. I submit that's the only question for this court. I think the department is arguing that this is a discretionary matter, and therefore the standards regarding whether or not competent substantial evidence supports a finding of fact don't apply. And I submit that that's not the standard. We specifically know under the statute that Chapter 120 does apply to Chapter 435 proceedings. And therefore, the standard of review for a Chapter 120 proceeding is whether or not there's competent substantial evidence to support the administrative law judge's finding of fact. In the Astral Liquors case from the Florida Supreme Court, the court said that discretionary agency action must be subject to judicial review to determine whether it meets the standard of reasonableness. I submit that even though the decision as to whether or not to grant an exemption is discretionary, that decision would not be reasonable if there's been an administrative hearing with a presentation of live testimony and findings of fact made by an administrative law judge, and if those findings of fact support that the client or the applicant is rehabilitated, and if there's competent substantial evidence to support that finding of fact, the department simply can't reject that. That's what Florida law says. So again, at the end of the day, I ask this court to review the record to determine whether or not the administrative law judge's findings of fact are supported by competent substantial evidence, and if they are, the department's final order must be reversed. Otherwise, there would have been no need for Chapter 120 in this case, and the court should say so. So people in the future don't go through this process of having a formal hearing before an administrative law judge, presenting witnesses, trying to convince the administrative law judge to agree with the position so the department can simply reject it without putting anything in a final order saying that there's no competent substantial evidence, without making any determination as to whether or not the findings of fact were supported. Thank you.